welcome everybody to the third Foil Island Learning event of 2024.
Yeah, that's not.
If you could put your microphones on mute, that would be great, just to avoid any background noise or dogs barking, phones ringing, that sort of stuff. That would be very helpful. Thank you very much. Don't feel obliged to put your camera on if you don't want to. We are recording this just for as I say, anybody who joins us on a regular basis will know that we do try to record these events. I'll keep letting people into the waiting room as they appear. And I think that's Mary actually. Mary, could you put your mic on mute, please?
Yeah, but I suppose it's the fact that she holds her out as being herself as being an orthopedic surgeon, and she's actually not.
So,
Yeah.
there you go. I had the luxury with
Teams
being able to mute
I'd offered
people
587171 on the basis that I was reducing, that we weren't paying the gym, and that reduced the special damages to 870.
There we go. We'll never know whether that's settled or not.
Mary will crack it out. May will crack it out. You're a better lady.
Right. Okay. Without any further ado, I'm going to pass on to Noel because he wanted the honour of introducing you earlier.
Thank you.
Absolutely. Good afternoon, everyone. My name is Noel Devons. I'm president of Foil Ireland, and I'd like to thank you all for taking the time to attend the latest seminar in Foil Ireland's ongoing series of CBD events. This particular CBD event is in relation to SI 49021, which will be of significant interest to us all. The delays in conducting litigation and the costs associated with such delays have long been an issue for us as practitioners in Ireland. This is particularly the case, and I'm sure we've all experienced this, when trying to explain the situation to clients residing outside of the jurisdiction. With this in mind, the new system that was introduced by SI 490 was heralded as breaking new ground in speeding up litigation in Ireland and making litigation more cost effective for all involved. SI 49021 has now been in place for almost 2.5 years, and we thought it an opportune time to take a look at how it's been successful to date and perhaps how it could be more successful in being implemented in the future. Aillil O'Reilly, Senior Counsel, has very graciously agreed to present in relation to this particular topic. Aillil has vast experience in operating at the coalface in litigation in Ireland, and he's ideally placed to offer his insights in relation to the SI and what the future of litigation and delays associated with litigation might be in Ireland. So without further ado, I'll pass over to Aillil and we'll await his insights.
Thanks very much, Noel. So what I'm going to do is I'm going to quickly go through the existing rules as they've changed. And there's been a change to those in 2022, refining part of how an unless order operates. And then I'll deal with, there's 3 or 4 cases since 2021 that have attempted to try to understand how the rules should work, or at least how, setting aside the default procedures, should operate. And they draw on existing case law, perhaps unsurprisingly. And I've got 1 or 2 comments as to I suppose the overall approach that we can see in the bar as to what the judges think they're doing and how they feel the new rules operate and what their comments are in relation to it. So we'll start with, I've got the slides here, hopefully as I click along, it will now change on your screen. So there have been 2 changes, one in 2021, in November 21, and they changed all of default of appearance, statement of claim, defence and counterclaim timings, and then default of pleading. And then in September 22, the Superior Court Rules Committee decided they wanted to refine how unless orders operated, how you pronounced them if you were a court. I presume because of the experience they'd had in trying to reconcile the unless order, the party looking for it, and the registrar who was tasked with trying to draft it, and the inevitable problems that flowed from that. So there's been some improvement in that in terms of a rules perspective. Order 13 was changed, which is the default of appearance rule, to allow a 28-day warning letter and consent to late filing of appearance, and then
Sorry, Aillil, I can't hear you any longer. Can you just hold on a second, please? Lost your microphone.
Did you hear any of that?
Yeah. Oh, yeah, you're back. That's great. Okay.
Okay.
Lost you for about 15 seconds. That's all.
About 15 seconds. Okay. Just to say that there were straightforward changes changing what you had to do to obtain judgment in default of appearance. And there was also a change to Order 81A, which deals with charges you give in aviation leasing. The changed procedure required a notice on the defendant, and you had to consent to late entry of appearance within 28 days. You can then issue your motion as long as you do the appropriate bits in the central office. And if you're successful, you have to notify the defendant within 28 days of the judgment being entered in the central office, and then serve a copy of the court order after that had been perfected. And that was relatively straightforward in terms of clarifying what had to happen in the High Court central office. In terms of what happened with the statement of claim, defence and counterclaim, this was an attempt to standardise the amount of time you had to deliver each item of pleading, to change it from 28 days to 8 weeks. So both for statement of claim and delivery of defence, it was 8 weeks in each case. It includes a defence to counterclaim, which is also expanded out to 8 weeks. For other situations where there's no defence in the counterclaim and it's merely a reply, that remains at 14 days. So it's not expressly stated that the defence to counterclaim is, the timing is increased, but when you look at how the rule operates and what the words say, that's its inevitable effect. Now, when we have considered how the judges have approached the change of the rules, there's a quote which appears in a couple of the cases, and the judges appear to have a party line. And the party line is that the changes were driven by a general tightening of the approach to compliance with deadlines and the expedition of litigation in light of the constitutional and convention, that's European Convention, imperatives of ensuring justice is administered efficiently and expeditiously. And if, as Noel says, that has the added advantage of being able to better explain it to clients, so much to the good. Where you fail to deliver a statement of claim within the time frame, you can apply to dismiss the action for want of prosecution. If you're the defendant, the court can extend time to deliver the statement of claim if it's satisfied that that's in the interest of justice. If you can't do that, there's an unless order dismissing the matter. And the same applies to delivery of defence. The plaintiff can apply for judgment with the court extending time for delivery if it's satisfied in the interest of justice. So you can see a harmonisation of the words, which again is a positive when you're forced to have the fractious fight over exactly what Order 27 means in a situation where your clients are driving you to it. The motion papers need to be served. If you comply with your default no later than 21 days prior to the motion being listed, it's not in the judge's list, it's struck out, and there's a relatively modest cost penalty relative to, I understand, some of the bills of cost that one sees floating around of €750 inclusive of that. So there's an incentive again for the defaulting party to get their act together, even though they're now faced with the motion for judgment. One of the changes that I referred to is a change in, it's called SI 454 of 2022. It changed Order 27, Rule 9. And that order merely requires the court, when it's granting an unless order, to set out exactly what happens for the unless order for judgment in default of defence. One of the challenges that the court says that it experiences is where you've got more than one relief or a relatively complicated statement of claim, it can be very hard for the registrar to identify what judgment in default of defence means. And it's nigh on impossible to get the parties to agree once the order has been granted. So when the court is making the unless order, it now attempts to determine as best it can what relief should flow from that unless order, which again, if we're following from Noel's introduction, ought, when it operates, to make the matter a little more expeditious and provide a little more clarity as to what happens next. What is, I suppose, more significant and relevant is, well, what happens if I get it wrong? What happens if I don't do this? Where the unless order is made or where judgment in default of appearance is granted or the case is struck out for want of prosecution pursuant to these rules, it can be set aside for judgment in default of appearance. Firstly, if there's a regularity on such terms as may be just, if it's regular, but there's no other ostensible problem, where the defendant has a good defence and in the interests of justice, so a stepped test, as you see in other aspects, and the court can vary the judgment in both situations on terms as it may deem just. Judgment in default, that's both the, in respect to the plaintiff and the defendant, can be set aside for the unless order if there's special circumstances which explain and justify default, and for default of defence in special circumstances which explain and justify default. And the advantage of the harmonisation of the terminology is obvious. It means that when the courts get or got to looking at what to do when you need to do this, when you need to set them aside, there's some ability to transfer in and to adopt jurisprudence from outside. So there are about 20-something judgments dealing with the rules, these rules, since November 2021. Only 3 or 4 of them are particularly relevant to getting an understanding of it. And the most recent of those, as is always helpful, tries to summarize all the earlier ones. The, I suppose, fastest step forward was a judgment from Cian Ferriter in a case called D'Souza and Liffey Meets, 2023 IEHC 402. And in this, Judge Ferriter was asked to consider what would happen in order to set aside an unless order in what was an employer liability claim. It wasn't professional negligence, it was a straightforward tort claim, but the court still spent time to consider exactly how Rule 15 operated in terms of set aside. So the first issue it considered was whether at the time of default there were special circumstances which explained and justified the failure. So according to Judge Ferriter's analysis, and he merely went through the terms of the order and tried to read it through, and it's about 2.5 pages of prose where somebody quotes the order. According to the terms of Order 27, Rule 15, the special circumstances allowing you to set this thing aside are considered at the date of the unless order and at the date of the judgment. So not only the date that Mr. Justice Bloggs grants you your unless order, but also at the date that the default occurs. In doing so, perhaps he'd been tipped off, but he has an extensive series of quotes, and I suspect this is where the Rules Committee were going when they cast their rules in a particular way. He cites a Supreme Court decision in McGuinn and the Commissioner of An Garda Síochána. So there's a degree of certainty as to his pronouncement on that. It's not likely to be appealed or overturned. So when you're looking at the special circumstances, it's not just when the order was granted, but also when the unless order crystallized or kicked in. The court, that is Judge Ferriter, he looked at the case law related to the renewal of special summons, and he concluded that the language was sufficiently similar. Renewal of summons, not renewal of special summons. He concluded that language was sufficiently similar. This was a safe place to proceed, and on that basis, he was able to import both the case law from McGuinn and also the case law. Also the decision of Murphy and the HSE. It's a Court of Appeal decision. Houghton J has a series of tests in it, and he took the, I suppose, relatively holistic approach that where special circumstances arise, it has to be decided on the facts of a particular case, and it would be unwise to lay down any hard and fast rule. What that appears to me, based on what Judge Houghton goes on to say, is that special circumstances is more than a good reason, which follows from the use of the word special, but not extraordinary. So some factor circumstances that is beyond the ordinary or the usual needs to be present. So from the factual matrix for the cases that have been before the courts where there's reported judgments, things that have not been sufficiently special have been outsourcing a requirement, so delegating responsibility to a particularly junior member of staff who makes a muck of it. That's not sufficient. Failure to have the Hayes DX deliver your post is a special circumstance where someone had taken steps to perform a particular measure, which if they had been performed, is good reason to think would have been complied with. That was sufficient. So again, as in many of these sorts of situations, the assistance from the court inevitably says, well, it depends on the individual facts of the case. That's always the case. It does make clear that mere inadvertence isn't enough. So it's not enough to make a mistake. So you're beginning to feel like you're moving back toward the old tests you got when you're looking at the era continental line of case law. But where there is something that takes you beyond what would typically occur, i.e. what you'd expect to occur, seems to be sufficient to be deemed special circumstances. For the timing of the special circumstances, Ms. Justice Ferriter cites another decision of the Court of Appeal in Nolan and St Mary's Diocesan School. And I suppose he focuses on an aspect of that judgment where the existence or establishment of special circumstances was perceived as as a two-step, almost like a threshold test, that the special circumstances would have to be established before justification for the renewal, in that case of the summons, under the rule. And the question of prejudice and interest of justice being part of the analysis of justification, not the question of special circumstances. So he really only looked at the extent to which Nolan had said almost there's two steps, that you don't get into the balance of justice, excuse me, you don't get into the interest of justice until you've found the special circumstance. A later judgment highlights another Court of Appeal decision, essentially going back to the approach of Houghton in the HSE case, where he had, again, a more holistic approach, where they were talking more about the overall balance of justice, or the overall considerations of the interests of justice being part of the considerations the court should take into account, meaning that they all might be considered close to simultaneously or perhaps coextensively. The issue of exactly which one should be first doesn't appear to have been required to be determined yet. And in a later decision we look at, Judge O'Donnell has a view as to why that might be. But at present, the special circumstances are typically first established. And in part of the consideration before him, Judge Ferriter was encouraged to accept the argument for him. He was encouraged to accept the idea that although the rules had changed, they should be seen as a little less demanding. And he had a quote for that, I suspect, not unlike the initial quote that I had at the second slide, which is from Judge O'Donnell. He said, so emphasising what the courts viewed of the change, and the courts certainly view the change, or attempting to view the change, as slightly tougher than the preceding situation. It is clear that in respect of both rules, a more demanding set of reasons or circumstances is required than under the old regime, as part of a general tightening of approach to compliance with deadlines and expedition of litigation in light of the constitutional and convention imperatives of ensuring justice is administered efficiently and expeditiously, which should assist. When Judge Ferriter, having found there were special circumstances, when Judge Ferriter went on to consider the interests of justice, I think I've incorrectly called it the balance of justice, he referred to the degree of complexity of the claim. In this case, there was an engineering report which hadn't yet been supplied. It was necessary for the defence of the case. That was a factor in why the defence was late overall, that there were multiple causes of action, that there existed an arguable defence for the party making and moving the application, and whether setting aside the judgment would result in prejudice to the plaintiff. Judge Verrett has just decided that in the circumstances, costs would be the appropriate remedy and that the case should otherwise proceed. In reaching that determination, he awarded costs of the unless order and the set-aside motion, but went no further. I don't think any further steps had been taken that were relevant, that were referred to in the judgment. There is a later judgment in Costern Unlimited versus Fenton. It is a judgment of Mr. Justice Barry O'Donnell. It was an unless order for judgment in a professional negligence case, so for a change, exactly what Foyle should be looking at. It refers to and follows the approach in De Souza, it's the earlier case from Judge Ferreter. And again, they were looking at how to set aside the default judgment. This is the point I was making earlier. It identified a difference in emphasis in the approaches from the Court of Appeal in Murphy and in Nolan. So the view of Mr. Justice O'Donnell was that Judge Houghton had a much broader approach. He essentially said, let's throw them all into the pot and see how it feels. Sorry, David. See how it feels at that point, that the interest of justice isn't a separate limb, but it's weighed in but instead is weighed in the balance, all matters when coming to a just decision. So his view, Nolan, characterized it more as a threshold test. Now he said, he said he didn't need to determine it in that situation, and he said he thought it unlikely that you'd have a situation where you'd have very strong balance of interest of justice arguments, but very weak special circumstances arguments. I'm not sure I share his optimism. Where you're losing the opportunity to litigate, it does sound like an extreme circumstance. So I suspect the nuance of the extent to which you can have a situation where it imposes terrible hardship on the defendant in a situation where I presume it would be a different party, not the client, but the client's representatives have completely mucked up and dropped the ball. I suspect that will end up being determined by one of the courts. And I suspect based on, so I don't know how that'll go, to be honest, because the courts appear to, in those situations, find a way to help those people who seem truly meritorious, where their circumstances are rotten. So perhaps it will be, as Mr. Justice O'Donnell suggests, but I don't share his optimism that it won't be considered. The court satisfied with the existence of special circumstances committing one default. That's right. So the other thing that Judge O'Donnell determined was there were two situations of default which the applicant in Costern was trying to get around. One, the defence was delivered late, and there was a problem with Hayes DX. According to the affidavits in the case, DX hadn't arrived, although having been put in good time. And secondly, and that was deemed to be by the court special circumstances, the second issue related to late filing in the central office. You were required in that situation to file the defence in the central office of the High Court. That wasn't done on time. And when the solicitor fairly owned up and said, that's entirely my fault, I wasn't aware of the change of the rules, because I hadn't reviewed the change of the rules sufficiently carefully, and I hadn't paid attention to the problem. And that's so he was, the judge said he was admirably candid. The court said, whereas that wouldn't be special circumstances in and of itself, when taken into account with the other aspect, that's the late defence due to the alleged problem with Hayes DX, the court was willing or felt it appropriate to not have a binary approach, not have the requirement that both problems or all of the relevant defaults should be caused by special circumstances. So again, that feels a little more like the broader approach of Judge Houghton and a little less like the stricter approach, if you want to call it that, set out in Nolan. 16. When Judge O'Donnell went through his analysis of the interests of justice, he spent a deal of time analysing the proportionality, essentially going through the associated constitutional and convention rights connected with litigation and access to the courts and access to justice. Viewed in that light, it becomes relatively hard to succeed in holding on to the unless order, because faced with the destruction of your claim by default without a determination on the merits, it's hard not to argue in a neutral situation that costs wouldn't be an appropriate remedy for that situation. Perhaps the timing of it might be something that the court might consider, or whether a stay is to be imposed, but certainly it seemed hard on that sort of analysis, if that's the direction of travel, to resist an argument of that type. Judge O'Donnell imposed not only the costs of a set-aside motion, but the costs of and associated with the preparation and service of the notice of trial. So in that situation, the plaintiff had proceeded to set down the matter for trial. Now, there was a deal of contest between the parties. I think there were over 350 pages of, according to the judge, fairly fractious affidavits. I suspect, and one of those, according to the judge, was whether or not all of the work done on the notice of a trial was complete. I suppose would be the best way of putting it. So you could see that there was a degree of contention. So perhaps in the light of that case, it was a sufficiently difficult penalty to impose on the defaulting party, simply by imposing the cost of the service notice of trial. There are two decisions from Miss Justice Heslin, and he has a decision in May and Barrett. Again, he considered it an unless order in a slightly different context, but he does consider an unless order. And he granted the relief to set aside the unless order, and in doing so, he emphasized consideration of the proportionality and the loss of the constitutional right. And again, in a subsequent case where Mr. Justice Heslin is dealing with a straightforward application to dismiss for want of prosecution at Order 122, he declined to dismiss the action, but demonstrated an increasing comfort in the courts with unless orders, and said the appropriate thing to do here is, rather than merely extend time to deliver, I think it was the statement of claim, he granted an unless order to hurry the case forward, which does seem to satisfy the overall objective of the rule changes, which is try to make litigation happen in a more predictable fashion. Miss Justice Egan has a further decision in Tacit Golf Club versus McDonough. This was an application for judgment in default defence, where the 28-day notice of the intention to bring the application had been served, but the judge said there wasn't evidence before her of service of the notice of motion within the requisite number of days, or of a letter drawing attention to the terms of the order. It's one of the requirements of Order 27 for the judgment in default applications. Judge Egan held that if you don't serve the 28-day notice, it is impossible for the party to proceed with the application, that she referred to it as a jurisdictional matter. She went on to say that the failure to adduce evidence of service, notice of motion, or delivery of a letter drawing attention, the requisite, the failure in the other aspects of compliance with Order 27 weren't fatal to the application, but where the moving party had been looking for judgment in default, they weren't granted that, and in the interest of justice, she said the appropriate order was an unless order. Now, if you think of the change from the time when, I suppose, when I was starting, when I probably only first heard of an unless order when Mr. Justice Kelly was granting them, and it seemed like this terrible thing. It seemed like a very severe penalty to impose on a party, to say, look, your case is dismissed unless you do this within a period of time. And there was always, with Mr. Justice Kelly, a degree of successful theatre about the way in which he imposed reliefs and remedies on the courts, or the lists he was running. And you now, which was admirable in Mr. Justice Kelly's case, but he's a singular personality with an unlimited capacity to work. Other people are mere mortals. It's interesting seeing the change. Other judges would have been very reluctant to grant unless orders, and that it would have been perceived as quite severe things. And now you've moved toward a point where Miss Justice Egan, recent and excellent appointee to the High Court, is happy to grant an unless order as a stepped down remedy, seeing it as, again, relatively straightforward. It just has to be a positive for the conduct litigation here. Ms. Justice Quinn, in a decision in November of last year in Everyday Finance in White, he helpfully summarises the case law, quoting now. He doesn't go into the level of comparative analysis that Mr. Justice O'Donnell did when trying to consider the nuanced differences between different Court of Appeal decisions. Instead, he sets out what he can see as the case law surrounding judgment in default of defence. He emphasised, again, that courts lean in favour of having the case run, and citing the Supreme Court decision in McGuinn and the Guards. He also refers to the general jurisdiction to set aside a default judgment obtained irregularly or in circumstances of mistake. Now, AIB and Ford is not a case that was handed down since the rules were changed. It relies on a different set of rules, but it's the same principles involved. He also referred to the inherent jurisdiction to set aside a default judgment obtained in default of appearance due to accident, mistake, or inadvertence when it's just and equitable to do so to achieve justice between the parties. So, again, referring to first principles judgments which precede these rules, which always apply, which underpin the logic and the jurisprudence that the courts have seen already. So that the courts have demonstrated when approaching the changed rules, essentially Order 27 and Order 13. I was in Bank of Scotland versus McDermott. And finally, in summary, there's a quote from Miss Justice Allen from a year and a half ago in McCann and Smurfit. It's a dispute about who is entitled to the proceeds of the sale of a courier company. In it, the court is encouraged to make an unless order, and in refusing to make the unless order, Mr. Justice Allen refers to a step like that as being a yellow card step. So, again, repeating what I was saying earlier about Mr. Justice Kelly, from a practitioner's point of view, it's a significant step forward to have the courts so comfortable with what is quite an extreme remedy to dismiss your case for procedural failure, that they're willing to describe that in a relatively flippant way akin to a sporting analogy for rugby. So I think that's probably a positive in terms of the progress of litigation, because it should keep cases moving forward. If courts are comfortable with making a self-executing order that'll destroy your case unless you get your act together, that should help. They do emphasize the overall proportionality of the circumstances when considering set-aside motions. And as I was commenting earlier, it does feel to me that it is relatively hard to permanently eviscerate the other side's case simply for being late in terms of compliance with an order, where payment of money to remedy the costs would be sufficient. I think typically in more commercial dispute type cases, one can see how parties will never agree and will always attempt to obtain the maximum leverage from any advantage they have. One imagines that typically professional litigants like insurance or insurers or indemnifiers tend to have a longer view, which is commensurate with doing the thing that is reasonable and appropriate, not losing an advantage they shouldn't throw away, but not in pointlessly or needlessly litigating it. If you can recover some of the cost for some of the steps taken in enforcing compliance with the orders by the other side, that would seem to be overall a positive. Whether the courts will continue to expect the moving party for the party resisting the set-aside application for either the unless or judgment in default orders to fight the motion and resist the case being reinstated essentially, and award costs in their favour, may change. So where there is some predictability on what you need to show the court to have the unless order set aside, it doesn't seem a stretch for an unlucky defendant in a situation where judgment has been granted against them to offer to take the appropriate measures, which is predictably costs and delivering the requisite pleadings within a period of time, and also setting out what the facts are that would justify special circumstances, and that is, broadly speaking, in the interest of justice. So I can imagine a situation relatively quickly where, faced with credible evidence that facts will, the credible evidence that facts exist that would permit the party against whom the default order has been obtained to set it aside, that a reasonable defendant will be encouraged to do so, to avoid pointlessly delaying a case by running the set-aside motion and seeing how far you can get. Noel, that's the end of my slides. I'm happy to answer or try to help with any questions, if I can.
Thank you very much, Aillil. That was a lot of food for thought there, and something for us all to take on board in prosecuting unless orders and defending them.
Yeah.
I don't see any questions from anybody, but obviously if anybody wants to pose a question now, they're more than welcome to, and hopefully Aillil will be able to answer it.
If we were meeting in person, Lawrence, we could say it was now time to go for a drink, but next time.
Next time, definitely. Yeah. I've got no questions in the chat room. No.
Okay. Look, I mean, the challenge with the challenge with orders like this is that they are relatively dry, and they are relatively uninteresting to consider until it's a problem, until you discover that a legal executive has overlooked something, and you now no longer have a cost order against you for a delayed defense or a delayed document. You have a problem explaining to the client why you have an unless order. So I think they're only really interesting when they happen to you, and then they're very, very interesting. And in that situation, I'm happy to have provided my slides to Foyle, and you can look at those.
Thank you, Aillil.
Thanks again, Aillil.
No problem at all.
Thanks, everybody. Thank you.
Sloan.
Thanks all.
Thank you.
Bye. Bye. Bye.